All right. Hey, this is Joshua Pondexter from Stone Consultant LLC. We want to thank everyone for attending our Lunch and Learn, which is an estate planning and living trust workshop. So we're going to discuss those topics. I'm going to give you an opportunity to ask questions and chime in as we go through this discussion. It's a little low key, but we just want to be respectful for everyone. Keep yourself muted. You come off to ask a question, put yourself back on mute, and we're gonna get started. And this particular workshop is fitted for slideshow is fitted for the screen, so to say, but it's fitted for the time. In three ways we mess up our finances, how to avoid them, and especially in estate planning. It's an estate planning workshop. So what I mean, I have an estate planning living trust workshop that's entitled 8 Ways We Mess Up Our Finances and How to Avoid Them. So in each one of those ways I could speak to for about an hour. Nobody has that amount of time. So we have condensed this to 3 major points. Okay, and we'll just show you what those 8 ways are we normally talk about in your finances. Probate, joint tenancy, federal estate taxes, taxes on Social Security benefits, inflation, and that's a hot topic today. We could speak to that at another hour. Market risk, right? The market is going crazy with the conflict, the war that's going on with Russia and Ukraine that causes market anomalies. Nursing home costs, not planning, right? So these are the 8 ways we can mess up our finances if we don't develop strategies to avoid them. Once again, we're not going to be talking about all 8 ways. So my perspective is that if we're designing an estate plan, we should begin with the end in mind, right? So the absolute end is when you die. So if you protect your assets with a plan that's designed to deal with death and work back, you can have a pretty good plan. You can develop a pretty good plan. So not planning to avoid probate is the #1 mistake, right? So what is probate? Probate is the legal process in which the courts make sure that after you die, your will is legally valid, your debts are paid, and your assets are distributed according to the instructions in your will. This is a misnomer. A lot of people think that if I have a will, I don't go to probate. Well, you have to go to probate to validate your will. So probate, this is what it is, the legal process in which the courts make sure that after you die, your will is legally valid, your debts are paid, your assets are distributed according to the instructions in the will. Well, #1, who wants to pay debts when they die, right? So we want to, probate is something we probably want to avoid. Why probate, right? So this is simple, it seems to be pretty simple. See, if your name is on title of an asset and you die, the only legal way to take your name off title of an asset and put the new owner name on is probate. Right? So title, asset, what is something? Your stuff, your house, your car, your bank accounts, your stocks, your money, that's your stuff. And as you see in the little picture there, it's something that's anything that you sign your signature to, that's your asset, right? And so my name is Joshua Pondexter. I do have quite a few Joshua Pondexter. I have a second and a third. and everything would be simple for my name to get removed from my stuff and put their name on it. No. And it's going to have to go through a legal process if they go to probate, right, to get my name off of the stuff. Right? And so this is important, right? What assets go through probate? Certificate of deposits, a lot of people don't have those anymore, but there's still some people do. Real estate go through probate. Businesses go through probate. Stocks go through probate. Bonds, mutual funds, personal property, right? A lot of people don't realize that your business will go through probate, right? So if you don't have your business assigned or that your trust own your business, that business is going to go to probate. Right? Surprisingly, not every asset you own must go through probate. If you own assets jointly or have a valid beneficiary, or you own life insurance products or use a trust, those assets will avoid probate. So understand, if you have a trust, those properties avoid probate, right? Life insurance, because with your bank accounts, your life insurance, you have a beneficiary, right? But as part of the estate planning process, we need to let you know that beneficiary arrangements have shortfalls, right? Say, for instance, you have your daughter as the beneficiary of all your goods, and you pass away, and your daughter is so traumatic by this incident that she passed away, right? And she's on her second or third husband. And so what that husband going to do, those assets going to belong to him and not the children. And he's going to go look for somebody to take those children. He's going to keep the assets, right? So beneficiary arrangements have shortfall. Assets hold jointly, right? So there's dangers to naming your children on your assets, right? So a lot of people do what I call shade tree estate planning. They add their children name to their homes, right? That's additional liability, right? And if you married and you got a problem with joint assets, I can't help you. You got to go talk to your preacher. But for this discussion, we want to understand that never, ever, ever name your children jointly on your assets, right? Because that's increased liability, legal, financial liability. Now, this is the probate process. It seems like it will go pretty quickly. A petition for probate to begin. The courts take control of supervision. The judge approve your will and officially appoint your executors. So you said, what? I had my child as my executor. Well, the judge will have to approve that executor, right? The probate system, they have a whole system of denying people executors so they can put in place one of their executors, right? This court legal process. Inventory all your assets and debt, right? So they're gonna come through and take inventory, all your personal goods, all your debts, everything that you have. I'm gonna pay your final bills. Final hearing notice to settle. Dispute settles and assets distributed. What you mean disputes? Well, when you go to the probate process, anybody can make a dispute. Your sister, your cousin, your best friend. Joe promised me, that truck, right? So now I'm in there disputing over his property. Right? Executors released and the file is closed. So this seems like a simple process, but this could take up to 2 years to go through this process, right? So that is the process. What's wrong with it? The cost. The average cost of probate is 3 to 10%. So you have a $1 million estate. That's with your single family residence, your retirement accounts, your stocks, your bonds, all those things that you own. That's $100,000 easily that can be stripped off of your estate, right? That doesn't go to the next generation. Will or no will. Time delay can average 6 months to 2 years, and this is dependent upon where you live. If you live in Texas, Texas is going to be a minimum of 3 years to take you to the process. Then AARP suggests there's $40 billion a year in probate fees, with 75% going to attorneys, right? So the reason that this is kept going, this probate process, is because all of this money. Then it's public domain, right? We're all private people, don't want to tell you nothing about our private business. Now your whole life is public. So your family lose control of your assets, right? So, and this is definitely what we don't want to happen. So this is what's wrong with probate. These items: the cost, will or no will, the time delay, 75% of the fees going to attorneys, the people that you don't know, your private life now become public, and the family lose control. That's probate. So quickly, any questions on probate? Go ahead, Joe. Got to unmute yourself.
Okay, so anyone can dispute the will, right? I mean, if yes. anybody.
Yeah,
you can have some brothers, sisters, or ex-wives, ex-husbands. They can dispute it, right?
Good. Yes, good point. That's the good to point out, because your ex-wife can, and you know, I know you got some stuff I like. I might want that Jeep, you know what I'm saying? So yeah, good point. If you have exes, right? Spouse, right? Now, they can dispute. That's why we're going to talk about the living trust, right? So that's the probate. The probate is expensive. Family lose control, will or no will, because we are under the false assumption that if we have a will, we're not going to probate. No, a will is an outdated estate planning instrument. It doesn't work in the modern world. Okay, all right. So now let's go to mistake number 2: not planning for the overwhelming cost of long-term care. So what are the odds? Number 1, right? We're living longer, but we're not living healthier. Recent studies indicate that 1 out of every 2 people who reach the age 65 will spend some time in a nursing home. That's too much, right? So the odds are extremely high that you or I will go to a nursing facility. What are the costs associated with long-term care? Right? So we have skilled nursing home care, intermediate nursing home care, custodial care, home health care. So, and all these are very expensive, right? Skilled nursing home care, state of Illinois is probably a minimum of $9,000 to $12,000 a month. That's more money than most people made a month in their life, but you're gonna have to pay that to go to a nursing home. Right? Very expensive proposition. Right? Who will pay? Medicare, 2%. They pay for them 100 days. Medicaid, 42%. Long-term care insurance. Families, right? So most families, they're going to try to keep, you know, the family member at home, but we don't live in that type of society anymore because husband and wife both got to go to work, right? You know, I know some families, they rotate around. You take care of mama for these hours, and then when I get off, I tell her it's just not practical, right? So we can slide at least 40% of that family up to Medicaid. So Medicaid is a big deal, right? And Medicaid, most people, if they go into nursing homes, even if they're at home, they're going to have to utilize Medicaid to pay for that care, and it's very expensive. So here's how Medicaid is devastating families in our community particularly, right? So let's look at what counts, non-countable things. So your home, your car, jewelry, a burial plan, $2,000 to $93,000, right? So these are assets that doesn't count in Medicaid spend down, where they say, well, come spend down until you have this amount. So let's start with the $2,000 to $93,000. Well, the $2,000 is for an individual. The $93,000 is for a family. In the state of Illinois, it's $130,000 that the custodial or the community spouse can have. That's the one that's not in the nursing home, right? So if you had $500,000 cash and you went to Medicaid, you had to spend that all the way down till you get to $130,000. Now they cap on how much you can have for a burial plan, right? $15,000, $20,000 at the most, right? So jewelry, cars, homes. So those are the things that don't count. Here's what count in Medicaid spend down. Your CDs, your stocks, your bonds, your mutual funds, vacation homes, cash investments, and there's a 60-month look back. That's 5 years. So if you were going to do some estate planning to get beyond that 5-year period, you want to start doing it early, right? Because say if I need Medicaid tomorrow, they can look back for 5 years and whatever was in my name or was under my control, they can count that in the spend down. So if I have $500,000 of cash, I'm gonna have to spend that down to $2,000 before Medicaid will start paying the nursing home. So actually a retirement plan could be devastated. The monies that I've been saving to pass on to the next generation will be devastated, right? Through this Medicaid reality. So is paying $1,500 to $5,000 a year for a long-term care insurance policy the only answer, right? No, I don't think so. It's not the only answer. So listen, probate, Medicaid spend down is devastating the life of average Americans. It's definitely devastating those who don't do planning. So we definitely want to get ahead with our planning. So at this particular point, before we go any further, any questions on probate or Medicaid spend down?
Hey, this is Daryl. I did have a question.
Okay.
All right. So thanks for putting on the seminar, allowing us to, to ask questions. My issue is this: my father recently passed, and they had a will. Mm-hmm. My mother's still alive, so they had a will and they had a trust.
Yes.
I'm kind of debating and going back and forth a little bit with this bank because they had assets in the bank. It was under his name, mm-hmm. the account, and her name wasn't on that one. But they're saying anything over 100,000 has to go to probate. My issue is that I've shared with them now the will, the trust, mm-hmm. and then they said, well, it wasn't written in the will. I said, well, it's a pour over will. She's a trustee as well as the guarantor.
Mm-hmm. Right.
Am I on the right page? I mean,
no, you're definitely on the right page. So yeah, you're definitely on the right page. They did the right planning, and as you stated, because they didn't get the assets, and it's $30,000 in the state. What state are you in? The state of Illinois.
Well, that was Illinois. They said anything over 100, I think it was 100,000. Yeah. She can't just take out of the bank. It has to be within the will, or it goes to its estate.
Right. So okay. So now, good point. And so you have the pour over will. And this pour-over will is a very powerful document. So those assets that you don't get placed into your trust, they pour over into the trust, right? And she's the beneficiary, the heir, the successor trustee, all that stuff.
Yes.
Yeah, you're definitely on the right path. They have no reason to hold your money. They might come and say, well, you need a trust account, right?
Okay.
So does she have a trust account? Bank account?
No.
Okay.
No.
Now it was their trust, right?
Right. They did this in about 2000, I think it was 2014.
Okay.
So, so she was a guarantor if he passed, he was a guarantor or an executor if she passed.
Right. So she was successor trustee. So what's happening? It was a joint trust that they had, right? So she should be able to go to her bank account and take those trust documents and become a signer on her regular bank account. And legally, you do not have to have a name on your checks, right? It's the signature card that's important. So if you go change that signature card, now that bank account belongs to the trust. Should be able to go take the memorandum of the trust paperwork itself, and get that done. And who is this bank?
Give me a Huntington or something. They bought TCF or something. She banked at. I think it's a Huntington.
Okay. Right. Yeah.
So,
So I would push their legal department. I wouldn't talk to their manager. This is kind of out of their privy, understanding the people at the local level, right?
Okay.
So great question. Matter of fact, if you would, definitely hit me up and let's talk about this and how we're going to approach that, because that's the power of the pour-over will, right? Yeah. So let me give you guys a little bit more information, and then we're going to open up for Q&A. So they truckloads of money with that. So what about the revocable living trust, right? So the revocable living trust is revocable, meaning that it can, you can make amendments, you can revoke it, you can tear it up if you want, right? Get rid of it. It's amendable. Trust held property, avoid probate. So this is why it's critical that we get all our properties into our trust, because we'll run up into the problem that the young brother was just mentioning there. And so sad to say, 80% of the trusts that are created go unfunded. That means that the people that established the trust for you didn't go through the funding process of making sure that you got your assets into your trust, right? Secure additional tax benefit at death. Nobody's jumping up and down about that, when it comes to a trust. And then you have control after death of your assets when they get it, right? Or if they don't get it, right? And so I liken a trust to a box. When you set up the trust, you are the trustor. You are the trustee, meaning you're managing it. The trustor, the guarantor, means that it was set up by your power, right? You're the beneficiary. Then you have successor trustees. You don't have an executors, so no need to go to assets or property. Don't need to go to probate. And then you have heirs. So this is the layout of the trust. The trustors, that's the guarantor who have the power. The trustees manages the assets you put in. Then you, the beneficiary, also you benefit from them, and you are the successor. Then you have successor trustees where the assets won't go to probate, right? Because this is what you're doing in your estate planning. You're preventing your stuff from going to probate. And we got time for Q&A. I just want to one more item, and then we're going to end one aspect and go on to the next. And so in my my planning, right, my estate planning, so our services include Medicaid planning, where we look at your assets and see what's exposed to Medicaid, right? We look at, you know, your tax reality and how that we can reduce taxes. We're avoiding probate court and attorney fees, and how to avoid double taxation on IRAs, 401ks, and pension plans. A lot of these accounts, especially 401ks and retirement accounts, if you give them to a non-spouse, double taxation is very possible, right? And so the documents that we prepare for the revocable living trust is a separate entity in itself. It can hold all type of properties, real estate. It can hold businesses, cars, boats, stocks, bonds, anything you could think of. And so we give you a memorandum of trust. This is what you show people that your trust exists. As a summary of the trust. They don't get a copy of the revocable living trust because it's a private and confidential matter, right? And then we give you doable general powers of attorneys, both for financial and for healthcare. A medical information disclosure authorization. Sad to say, the third leading cause of death in America is physician mistakes. So the last thing they're going to want to do is give up those medical records. They want to hide by the HIPAA law. This document right here prevents that. You know, forthwith, give me the medical records to my estate. Living will, this is the right to die. The portable will, which the young man mentioned, it is a powerful document, right? He should not be having these problems with these uninformed people about their property, and they have a trust to pour it over in, right? Number 10, and so as I stated before, 80% of trusts that are written go unfunded, meaning that the assets are not transferred. So we ensure that our clients' assets get funded. The warranty deed, we utilize that to transfer real estate into your trust. Personal items, we talked about probatable. Folks fighting over dish sets and watches and diamond rings and fur coats, right? So all that goes into the trust, and it gets distributed according to the dictates of the trust. The bill of sale of general, we can sell our cars, our homes, our business, not homes, but our cars, our businesses, things in that transfer boats to the trust, right? Certificate of deposit, insurance, bank accounts, securities and stocks we can put in the trust. So we have a very comprehensive package that we provide to our clients, and we do this in all 50 states, right? So there's not a state in the union that we do not offer this service, right? So suffices to say, that was a quick estate planning workshop. We ask that if you have any additional questions, you contact me via joshuapondexter.com. And please like and share and comment on this video. Thank you so much.